All rise. Please take your seats. Caribbean Court of Justice Appellate Jurisdiction on appeal from the Court of Appeal of Barbados, CCJ application number 1 of 2019 between Pedro Deray, also called Deray Ellis, versus the Director of Public Prosecution for the hearing of the application for special leave to appeal. Can we have the appearances for the court, please? Thank you.
Good morning. May it please your honors. My name is Larry Smith, and I appear in this matter in association with my learned friend, Mr. Cody Hines, on behalf of the intended appellant.
Good morning. My name is Oliver Thomas. I appear for the Crown in this matter with my learned senior, Mr. Alston Seal, Principal Crown Counsel.
Yes, good morning, Counsel.
Good morning, Your Honor.
Mr. Smith?
Yes, your honors.
Yes, proceed.
Yes. At the outset, your honors, firstly, I want to convey my appreciation for the court bringing forward a date in light of my indicating that I was traveling shortly. Your honors, this is, as the court is aware, this is an application application for special leave to appeal, and for leave to appeal as a full person. I believe we can take it, your honors, that the court is seized with the application, the affidavits in support and in opposition, as well as the written submissions,
Yes,
and the authorities.
To our sadness, we have read everything. To our sadness, we have read everything.
I am sorry, your honors, to have brought the court sadness. Your honors, the notice of application would have been filed in this matter on the 14th of March. And the intended appellant seeks certain orders, set to paragraph 2. I would not read them as the court is seized with the application. I would go straight away then, with leave of the court, to the special leave, the grounds of the application. Paragraph 8 on page 7 of the record, it states that the intended appellant argues that he's a fit candidate for special leave to appeal under the provisions of Section 8 of the Caribbean Court of Justice Act, and that it presents an arguable case. He seeks clarity in an area of law regarding applications for bail, the role of the Crown regarding providing evidence in support of any objections made to an application for bail. 3, it seeks clarity as to the procedure and or guidelines which ought to be employed by judicial officers in the disposition of applications for bail, and there's a strong likelihood of success. The intended appellant indicates or submits he has an arguable case that the length of time he has been on remand without trial, that from May 2013 till present, the intended appellant, at the time of filing, that was approximately 70 months. It is also the intended appellant's submission, at paragraph 2, that the Court of Appeal of Barbados, in determining this appeal, gave no consideration to its own delay in the matter. I too am sad, your honors, that in a matter that relates to bail, which concerns the liberty of the subject, that on an application on the appeal, which was filed on the 2nd of March 2017, the Court of Appeal of Barbados took 1 year and 5 days to hear the appeal. Then, more egregious, your honors, is that the court then took 365 days to deliver its decision in the matter. And none of this found its place in the judgment of the court or any consideration of the Court of Appeal as to granting the intended appellant bail, then the appellant. Now, it is the intended appellant's submission that the Court of Appeal may supply the evidence in the exercise of its discretion by asserting that the intended appellant had admitted to the killing in this present case, and that was an admission of the commission of the offense.
Sorry, Mr. Smith. You have skipped the third limb or element that you mentioned on page 8 of your application.
Yes, Your Honor.
I'm quite curious about that. Is there any further
Yes.
thing to be said about that? Is there any further information?
Well,
Sorry, for those who don't have the
I-
papers, this is the statement that since the decision of this court in Nervé and Severin,
Yes, Your Honors.
which found that the mandatory sentence of death for a conviction of murder is unconstitutional, there have been
Yes, Your Honor.
no trials for the offense of murder. And you say
That
there
is
is no
correct, Your Honor.
indication as to when these peculiar set of circumstances will end. As a result, without the intervention of this honorable court, the intended appellant is set to remain on remand indefinitely. The Court of Appeal failed to take into account this factor in exercising its discretion to withhold bail. Is there more to be said on this?
Well, it is a bit confusing, certainly on our end, Your Honors. It is our this matter has been set. The trial has been set for the 7th of October, but only recently I became aware that there seems to still be some confusion as to whether the issue surrounding the mandatory sentence of death for a conviction of murder has been settled. It was reported in the press that the judges of the Court of Appeal in the matter only maybe a week or two ago had indicated that a conundrum still exists. The Attorney General seems to be of the view that there's no hindrance from murder trials going on. But certainly at the time of filing, that was the case. So I believe that my learned friends on the other side, being the ones who are charged with prosecuting people in the country for criminal offenses, might be better able to speak to what the circumstances are. But as I understand it, only recently there appears to be some confusion still abounding.
President, can we ask the other side to intervene?
Yes, can we ask Mr. Seeley perhaps, if you could enlighten us about this issue of the moratorium, it seems, on the trial of murders?
Your Honors, as far as I am aware, we are all set to do murder trials. In fact, murder trials are set for in the new legal year. Unfortunately, we are down to the end of this present legal year in another 2 weeks or so. But murder trials have been set for September, as soon as the new legal year opens. And many of the other prosecutors are in possession of matters that are set and have trial dates. So I am not aware, Your Honors, that there is any moratorium on trials in Barbados.
Just to be
that
perfectly clear, Counsel, as far as you are concerned, this matter will proceed on its scheduled date, as far as you are concerned.
As far as I am concerned, and I think all the officers at the office of the DPP, we have had instructions from the learned DPP, Ms. Barbera QC, that we are supposed to set down matters and proceed. So
Thank you.
I see nothing affecting that.
That answers me. Thank you.
And you have your witnesses lined up for the 7th of October for this matter?
Well, for that matter, I think we have the witnesses lined up. I think they were started already to get the witnesses lined up, but we will do so in earnest as it comes a little closer to the time. But we have found the witnesses. We have the witnesses. It's only that we warn them early. We speak to them earlier and closer to the date to remind them.
Okay. Now, Mr. Smith,
Yes, Your Honors.
in light of these statements, if not assurances, what you are essentially seeking is a remedy between the period now and the 7th of October.
Your Honors, in simplicity, that is what it would be. But it's a remedy for 6 years on remand without a trial. And it speaks to the issues that the Constitution allows a person, if not brought before the court in a speedy fashion, within a reasonable time, to be released with or without conditions. It is not simply, with the greatest of respect and all due deference to this honorable court, a matter of between now, July 19th, and the 7th of October. Because, you know, while when we conclude this matter this morning, both the members of this honorable court and the members in this room, the council in this room, we will get up and leave here and enjoy our weekend. My client remains in prison. And that is a consideration.
Mr. Smith, I return to my statement. What has transpired between March 2013 and today, there's little we can do about by way of bail. That's already gone. So that essentially, what is an issue is you want to get bail between the period now and the 7th of October, assuming that the 7th of October is a date on which the trial will begin.
Yes, Your Honors.
Okay.
And if I may add, Your Honors, humbly, that while that is what we seek in terms of bail between now and then, it is in consideration of the inordinate time spent in prison while awaiting the trial.
Yes.
So
We know all the grounds for seeking the relief between now and the 7th of October. Between now and the 7th of October is what, 3 months?
It is, Your Honors.
Yes. So, won't you agree to an order that we adjourn this matter to a date shortly after the 7th of October, and let us see whether the trial has begun, or whether you have been further frustrated?
Your Honors, based on my instructions from my client, if the court is minded to make such an order, it has been my duty and obligation for 22 years to comply with court orders. But it is also my duty and obligation to put my client's case. And in that vein, I cannot agree, with respect and all due deference to this honorable court, to an order by consent, as counsel for a man who has been in prison for 6 years, to allow him to continue to remain in prison, Your Honors, for a further 3 months, while we wait to see if the court system in Barbados, with which we are all too familiar, and in delay that it inflicts upon the citizens of this country, to wait another 3 months to see if we will in fact have a trial. And then if we don't have a trial, then the order would be, or question could be posed legitimately by this honorable court, is that the remedy we are now seeking, because we can do nothing about the additional 3 months that have no past. We can only deal with the going forward from here, and the goalposts will again be moved. With the greatest respect, Yours, I humbly submit that, in the words of Moses to Pharaoh,
So you prefer to risk your application being dismissed altogether?
Sorry, Mr. Smith, may I?
Yes, Your Honors.
I
Yes,
know
Your
you were
Honors.
about to answer my brother, the President, but may I bring this factor to your consideration in giving that answer? And I do appreciate that I am disrupting a line of communication. But your application today is for special leave. If you were
Yes,
to
Your Honor.
succeed, you would be
Yes, Your Honor.
granted an order that you have special leave to appeal. You will then
Yes, Your Honor.
need to prosecute an appeal.
You would have to file
Yes,
a
Your Honor.
notice
You'll
of
have to
appeal.
file a notice, there'll have to be time for submissions to be prepared, etc., and for this matter to get to a state where we would hear the appeal if special leave is granted, which remains very much in the balance. That would
Yes, Your
take
Honor.
us, this is what, the 19th of July. That would
Yes, it is, Your
probably
Honor.
take us into the court vacation, etc. There
Yes, Your
would be
Honor.
the delay in considering the matters which need to be properly and fully considered. I noticed, Mr. Smith, to your credit, that there was, while awaiting the Court of Appeals decision, the 1 year that it took, you took the very prudent step in vindication of your appreciation that your client was languishing in prison. you made another application for bail, etc. So there is not any mistaking the zeal, the sincerity with which the bail is being sought. But I'm just raising these as practical considerations to see that even if you get leave, even if you argue the appeal, it will take us a number of weeks at a minimum nearer to the scheduled trial date.
I would go further, Mr. Smith. You see, because the holidays are almost upon us. And so unless you successfully prosecute a case for urgency, then it is very unlikely that even if you were to succeed in your application for special leave this morning, that you will get a hearing of the substantive matter before the date on which we would be prepared to have adjourned the matter. But I understand your position. You don't want to consent that your client spend a further 3 months in prison at a minimum. So what we can do is to say that we will make an order that the matter be adjourned to perhaps the 16th of October on the condition that if it is not started, if the trial has not commenced on the 7th as scheduled, then on the 16th, we will treat your application for special leave as the appeal if we were minded to grant special leave. So that if such an order is made, you would have really lost little or nothing, because even if you were to be successful today, it is very likely that the date that you would get for the hearing of the substantive appeal would not be a date very far from the 16th of October anyhow.
But is the court prepared to hear me?
But of course.
Your Honors, I am troubled, not with the proposal of the court per se, but the impact that it has. The court could only deal with the matter as it has come before it. I am mindful of the case last year, May, of Ventos and the Electoral and Boundaries Commission and those other matters, which were heard and determined at short order. In short order, when, because an election was 2 weeks away, 1 week away, and this court was able to meet, using the technology that was available to it, to ensure that that matter was heard in a timely fashion. It is our respectful submission, Your Honors, that if liberty of a subject in constitutional democracy is not the most paramount of constitutional freedoms, even rising above the right to vote, then I don't know what else there is to do. I must submit humbly, Your Honors, that it is disconcerting that in a context where the Court of Appeal, headed by then Justice of Appeal Burgess, now a member of this court, would have taken a year to deliver a decision in a matter, that the court will now find itself offering a solution which essentially contains the spending of more time in prison. So until we see what a court system, which this court is fully aware is broken, to say the least, and let's move the matter down to October 16th, and let's see what happens. The historical evidence as to what happens in these courts is available to this court. This court has pronounced on it in Frank Gibson, in which I appeared before this court. Justice Blackman, as he then was said, is a systemic, pervasive culture of delay in Barbados, and that has not changed, Your Honors. And so the concern that I have for my client, because as I indicated to the submitted to the Honourable Court, at the end of this, whatever order the court makes, I will take my bag and I will leave. But what is concerning me is that my client, when I report to him that the court's position is, let's wait till October 16th, Let us see what happens. If the trial doesn't happen, we'll treat the application for special leave to appeal as the application for leave.
So,
as
Mr.
the notice
Smith,
of
you prefer to hear your matter and for us to tell you to file an appeal within 21 days, to allow the DPP, the department, to serve an affidavit in opposition, and they have 21 days to do that, or 14 days, which would take us well into the middle of August, when we have our court vacation, and for us to give you a date in November. That's what you would prefer. Because if that is what you want us to do, then we could do that.
Your Honors, I think maybe perhaps I'm not making my submissions clear to the court, and and I apologize for that. The submission is, well, firstly, in relation to the affidavit in opposition, it is our submission is that the affidavit on opposition currently before the court is out of time. We have made all written submissions in relation to that. Those submissions are before this
Mr.
honorable
Smith, you
court.
don't understand. This is an application for special leave.
I understand that
If
fully
your
well, Your Honors.
application is granted, the appeal has to commence.
Yes, Your
There are
Honors.
certain procedures that must take place for that appeal to commence and to take its proper course. It is most
Of course, it is
unlikely
open to Your Honors.
that those processes will be completed before the court goes on vacation, so that we'll have to have a case management conference. We'd have to set a timeline for written submissions to be issued, to be made. We'd have to set a trial date. And all of that, I'm suggesting to you, may very well take you down into November. But that is what you seem to
I
prefer.
sense the court. I sense the court's position in the matter, and the concern I have is that certainly let's even presume that a trial is had on the 7th of October. It is our submission that certain important issues arise in this case as it relates to bail applications in general, as it relates to something as simple and as obvious as the definition of murder, as to the issues as to what is self-defense and it being the antithesis to an offense or charge of murder.
Mr. Smith,
That if this
you can't use the apex court as simply a court to give legal advice or to pronounce on theoretical issues, no matter how they're important. We are dealing with the case of Mr. Pedro Ellis, and we are trying to
I agree,
find
Your Honors.
the most appropriate solution to Pedro Ellis's dispute, which is before us. That's what we're dealing with.
Yeah, the only question, I can't pose a question to the court. My only thing would be, and rhetorically would be, what is the price of liberty? Is it the price of case management orders? Is it the price of having to wait 3 months? What is the price of liberty for a person who has been in prison already for 6 years? And I don't have an answer for that question. My submissions already indicate to the court what the views are on behalf of the intended appellant. It is left for the court to determine what the price is on my client's liberty, having spent 6 months in prison. I leave that for this honorable court
With
to
respect,
decide.
Mr. Smith, I think that is being quite unfair to this court, that we are to determine what is the price of your client's liberty. We can only deal with matters which come before us. Do not lay upon us the blame or responsibility of what has taken place over the past 6 years. What we are trying to do is to expedite this matter, and we are trying to find a solution which affords the best remedy for your client, consistent with fairness to all sides, all parties, and the society. You raise, for instance, the matter of appeal in bail matters, etc. That is a lovely discourse. It is, however, not an issue which you are able to raise because you got jurisdiction pronounced in your favor. So all of these things are out there, but we can, as the President indicated, only deal with this case which is before us, which is that of your Mr. Ellis. A
Yes, Your
question which I did not even bother to raise is, what is the order that you think ultimately you could get this court to make in favor of your client if, for instance, it were to hold in support of your submissions that the Court of Appeal erred in its considerations, etc.? All of these are things which are out there, Mr. Smith, and they are not easily resolved. So please understand, we understand the complexity of this, we understand the individual's interest in this, and we understand the broader questions which we need to consider.
Mr. Smith, I think we've carefully looked at your submissions, and unless there's something additional that you wish to say.
The only thing I would say, Your Honors, is that it certainly is not my intention, and certainly it was not the submission to lay any blame at this court's feet. I am fond of the court, so I would not lay that blame at the court's feet. My challenge is domestic. But be that as it may, I am looking to this court, quite honestly, for this court to resolve the issues that were raised. I will be guided, as I always am, by whatever decision that the Honorable Court should make in the matter. I would just want to place on record, which I believe I have, is that dealing with the matter 3 months henceforth, while my client remains in jail, is not what I would prefer.
Yeah,
I would don't mind dealing with the matter 3 months
just now. You either don't quite understand the nature of the order that was thrown out, which can be made, or you are misrepresenting its import. Because nothing would be lost, as far as your client is concerned, by the 3-month period that will elapse. Nothing will be lost. Because even if you succeed today, he's not going to get bail. All that you would have succeeded in persuading us to do is to allow you to argue an appeal. And that appeal, for it to be processed, will take time. The order that was, the proposal that was thrown out is that we will truncate all of that time on the 16th of October by treating the application for special leave as the appeal itself. That was not an application that was made for this particular hearing. So you're not going to lose anything. And I quite frankly don't understand your hostility to that proposal, because to my mind, it is in your client's interest.
It certainly is open to this court in the interest of justice. I would respectfully submit, notwithstanding this is an application for special leave, the court can, if it was so minded, to grant bail pending the hearing of the appeal in October.
No, then you will be getting the very relief that we are asking you to argue whether you should or shouldn't get.
I am guided, Your Honors.
Mr. Smith, Mr. Smith, you would have to do a lot to persuade me that we would be able to grant bail, theoretically and practically. So we would call the sureties before us, we would set the conditions of bail, etc., etc.?
Well, this court in the Frank Gibson case, when he appeared before it on the 10th of June, I believe, 2010, this court had reduced the surety from a sum of $25,000 to $10,000.
Yes.
So while the court did not interview the sureties,
right,
the court still did treat with the issue of bail.
Yes.
It did a review of an act done by a trial court.
Yes.
That's different from
Your Honors,
taking upon yourself de novo to do those acts which, in the normal course of things, trial courts will do. But let's not get into that.
as the court pleases.
Is there anything further?
I'll
you
be
want to
guided by
tell
the
us?
court's order.
Yes,
No, I'll be guided by the court's order.
yes. Mr. Seeley, or is it Mr. Thomas?
Mr. Thomas?
Yes.
Yes, Your Honor.
Now, as I suggested to Mr. Smith, we would be minded to adjourn this matter to the 16th of October at 10 o'clock. We fully expect
Yes, Your Honor.
that the trial will begin on the 7th. If it does not begin on the 7th, then we will hear this application on the 16th. But we will treat the application on the 16th then as if it were the appeal itself, if we were minded to give leave. And therefore, if there are submissions which you would have made in the event of the appeal that you have not yet made, then you should ready yourself to make them. Because if this matter is not commenced on the 7th, we would hear it on the 16th and treat it as if it were the appeal itself, if we were persuaded that special leave should be granted. Do I make myself clear?
Yes. I'm guided, Your Honor.
Yes.
It seems to me, counsel, sorry. It seems to me
Yes,
that
please.
you will need to be prepared as you see how things are leading up, and I say this to counsel on both sides, you will need to be prepared to have submissions ready, etc., if you see that it is looking shaky or doubtful whether the trial will proceed on the 7th. Because we will proceed on the 16th if the trial does not proceed on the 7th. So be ready, as the President has indicated, to argue the substantive appeal if, as a first stage, on the 16th, we grant special leave. Yes?
I'm guided, Your Honor.
Now, if the matter is commenced on the 7th, then we would let you know before the 16th that we will stay this application so that you don't need to bother to come on the 16th. We would just alert you by an order or some form of communication.
As the court pleases. Your Honor, if I...
I'm sorry. The honors,
Yes,
following from what His Honor Mr. Justice Barrow would have said, in the event that it is looking like the trial might not commence on the 7th of October, is the court minded to give it some timelines as to when we should file those submissions? Because the concern I have, I don't know if it's a reasonable concern, is that come the 7th and there's no trial, then we have essentially 7 and 3 and 6, 9 days in which to have submissions for the court to read and so on. So I'm just wondering whether the court is comfortable with that timeline of a 9-day timeline. or whether
Would
the
it,
court
Mr. Smith, would it be helpful to ask you and your colleague, your brothers on the other side, to work out a proposal as to what the timelines should be and submit it to the court?
Yeah, we can do that, Your Honors.
You can do that.
Yes.
okay.
I was wondering why the PPP was resisting the application for special leave, because as Mr. Smith has remarked, there is this point whether the Court of Appeal can just have jurisdiction to deal with bail applications. And that seems to be a very practical point. It goes beyond this particular case. That is an issue which I think the prosecution would want the court to deal with. So I was wondering, to be very practical, why not consenting to giving leave. Then we have that phase behind us, and we prepare for dealing with this case. And if there is no beginning or if the trial has not started, okay, then we go straight into that. I don't know if that is a possibility, but it seems to me that it is important for the prosecution at least to know that point because of the practical consequences. It needs to be resolved one way or the other.
I'm guided by your honor.
Counsel, I would also like to see that both prosecution and defense put their heads together to ensure that this matter is started on the date that is fixed. I think the time has come throughout the Caribbean for matters, especially of this nature, where someone has been on remand in prison since 2013, that there should be every effort made to make this matter start in October. The time for fixing matters and just adjourning them as if we're going through, just sort of jumping through hoops. I can't understand why this must continue. So I call, please, on the Defense Counsel and the DPP's office to ensure that this matter is started. I think that is what this matter deserves.
As the court pleases.
Now, I heard Mr. Thomas, I think, say that he was guided by my remarks.
To come to that.
But what I want to hear is whether he would consent in giving leave.
I agree consent.
Not just guided, consent.
Sorry, the question is the DPP consenting to the grant of special leave?
Yes, Your Honor, we're consenting to the grant of special leave.
Okay, good. So at least, Mr. Smith, we have moved forward a little bit.
Yes, Your Honors.
Your Honor, I just wish to clarify one issue related to the order of the court.
No, the order hasn't been made as yet, but go ahead.
Well, your proposed order, rather, Your Honor. It's anticipated by the prosecution that the defense will raise an application to stay the prosecution on the basis of pretrial publicity when the matter is due to start. So I'm just wondering whether the order will be contingent on any delay by either side. That is what I wish to clarify at this time.
No, sorry, go again. I don't think I follow you.
Okay. Yes, Your Honor. It is anticipated by the prosecution that the defense will seek to stay the prosecution of Pedro Ellis on the basis of pretrial publicity.
Adverse.
Or adverse pretrial publicity.
Yes, but that application would be made to the trial court, wouldn't it?
Indeed, sir.
So then the case would have started.
Very well. Very well, sir.
So,
Grateful to your honor.
by consent, and the court having been satisfied that this application raises important questions of law, special leave is granted. A notice of appeal should be filed, Mr. Smith. How long you need to
Yes, Your
file
Honor.
it?
21 days, Your Honors.
Notice of appeal will be filed within 21 days. And
Unless you want to cancel your vacation, and then you can do it quicker.
If it means that my client might be granted bail and be free, I will do whatever is necessary, Your Honors.
Okay.
so special leave is granted, and notice of appeal is to be filed within 21 days, and the rules will take their course. The matter is fixed for October the 16th on the condition that if the substantive trial commences on the 7th of October, then the court will consider staying the appeal. And we will let you know sometime between the 7th and the 16th what course we will take in relation to the pending appeal. I think that's it.
Yeah.
And the parties are to agree a proposed timetable in relation to written submissions and to submit it to the court within
Just,
I beg your pardon, Mr. Smith?
yeah, sorry, Your Honor, sorry to cross you. Just one thing, the court had indicated earlier, and I didn't want the court to rise without me addressing the issue, that the court found that, the court felt that there was some hostility. There's never any hostility from me to the court, Your Honors, but I believe passion I do have.
I see.
Passion for the law.
And I withdraw the term
passion for
hostility.
law.
I think passion is a
Thank you, Your
more
Honors.
appropriate word. Yes.
Thank you, Your Honors.
Yes.
Thank you, Your Honors.
Okay, I think the application also concerned the poor person part.
Yes, it did, Your Honors.
Yeah, but that is not really necessary because in criminal appeals, that doesn't have any real impact, so we can leave that.
As the court pleases.
Right.
And you can tell your colleagues that in future, they do not need to apply for permission to proceed as poor persons, since there are no fees that we charge in criminal matters.
As the court pleases.
Yes. Okay, so we will have the order drawn up and sent to you, if not before close of business today, certainly by Monday the latest.
As the court pleases. As it pleases the court.